A lot of people ask me what the words without prejudice mean, and you will often see these on legal letters sent back and forth between solicitors or barristers. But lots of people put this at the top of a letter, not fully understanding what it means. So today I'm going to talk about what the meaning of without prejudice is, what the scope of that is, why it's used, and why it might be important for you. But first of all, if you're new to me, I'm a barrister who helps you understand law, so make sure you hit the subscribe button and the bell icon and you'll receive notifications of new videos. So first of all, let's look at why we are using the term without prejudice in the first place. You may know that if one party makes an admission as to the case against them, whether that's a civil or a criminal case, then any of those admissions, subject to any hearsay rules, are generally always admissible against that party. But what if a party wants to make an offer of settlement during the course of a dispute, but without making admissions against themselves, which can then be used against them in court if the case ultimately ends up at trial? Without prejudice means that you are writing something without prejudice to yourself. In other words, you are writing something to the other party, but you don't intend for that to be used against you during the course of the trial. So simply put, subject to various rules which I'll come back to in a moment, if you write something that is without prejudice, typically it will be an offer of settlement, then anything that you've said within that letter cannot be used as an admission against you when you come to trial. And just to be clear, when we say admission in this context, we're not talking about a formal admission against yourself in this context, rather anything that might be against your interests or contrary to your interests with the matter at hand. And the meaning of admissions within the context of a without prejudice letter will be given a very broad scope and will effectively cover all of the matters discussed or stated in the letter. As to some of the rules for without prejudice, they are relatively straightforward, but it is important that you understand what they are. Otherwise, the cover of without prejudice may be lost. First of all, one of the requirements is that there must have been a dispute in existence at the time when you write this letter and cover it with the heading of without prejudice. Otherwise, a disagreement may arise as to whether there was a dispute at the time that the letter was sent, and this will generally be decided on the facts. Another rule is that for a letter to qualify as without prejudice, it must be a genuine attempt to settle. In other words, you cannot write without prejudice at the top and then write some kind of threatening words inside. If you do not settle this, then we will do X, Y, Z. If that amounts to some kind of threat or oppressive language or behavior, then you may very well lose the cover of without prejudice within that letter. So just to summarize that position before we move on, a without prejudice letter is generally written to make offers to the other side, but without having anything in the letter used in court against you as some kind of admission or contrary to your interests at the trial. However, as I've said, it must be a genuine offer to settle. It cannot be oppressive language written without prejudice so that it can't be brought up in trial to show that you've behaved badly. Any oppressive language or threats within that letter are likely to render the letter admissible as evidence, regardless of whether it is marked as without prejudice. And generally, the reverse is true as well. If you write a letter but you don't tag it as without prejudice, but within the letter it is clearly a genuine attempt to settle the dispute, and there's no oppressive language or threats within that letter, generally that letter will be taken to be without prejudice, whether or not so marked. It's also important to remember that these letters can be exchanged pre-issue as well. That means before the case is actually live in court. In fact, it is good practice because court should be a last resort. So you can exchange letters with a disputing party, exchange offers with each other to settle the claim before anything is filed in court. If all that fails, then you can ultimately end up in court, and those letters will remain without prejudice, or as some people think of it, as private. Private being the court won't look at it during the trial, at least not until later on, but I'll come back to why that's important in a moment. And equally, not every letter that's exchanged between parties before the issue of proceedings will be without prejudice. Some of them will be what we call an open letter. This might be an open letter to settle, which is intended to be open, intended to be used. An open letter may, for example, contain statements of facts as to the position of the parties, so that when it gets to trial, it may well form part of the arguments as to why the parties shouldn't be in court and should have settled the dispute. And I think it goes without saying that the without prejudice tag on a letter offer to settle will apply whether or not that offer to settle results in a settlement. In 2015, the High Court ruled that without prejudice can apply to communications with regulators as well. Equally, in 2016, the Court of Appeal ruled that statements made by a litigant in person, that is someone without a solicitor, made to the solicitor on the other side, were also covered by without prejudice privilege. And it has also long been the case that communications with third parties may also attract without prejudice privilege. If, on the other hand, you do reach a settlement upon which the terms all parties are agreed, then it makes sense that this settlement itself does not attract without prejudice privilege. Because after all, the term without prejudice should mean that it is without prejudice to that party if the terms or the offers or the statements made are not accepted. But if they are accepted, there is no need for those statements to be without prejudice, because ultimately the settlement was agreed between the parties. A very important distinction, however, is when two parties are talking and they agree that they are having a conversation, quote, off the record. This has no particular legal status and it should not be used lightly. In any such situation, for example mediation, which I will come back to, there should be clear statements between the parties that this is a genuine attempt to settle and is intended to be covered by without prejudice. So if you are worried that you write something in a without prejudice letter, that the other side is going to take it to court to sort of prove that you were wrong, there are consequences for the party that does that, so long as the without prejudice label is upheld. Generally, where it was indeed a genuine attempt to settle and intended to be without prejudice. In those sort of scenarios, the court may well sanction the disclosing party when it comes to costs, or even, in some extreme cases, the judge may recuse him or herself from the case. Finally, for this introduction video to without prejudice, there are of course some exceptions where the without prejudice rule simply cannot apply. One such example, which is fairly technical, is where the issue is whether or not the without prejudice communications resulted in a settlement. Whereas a fairly obvious example of where without prejudice cannot apply is in the case of misrepresentation, fraud, or some other kind of undue influence, such as threats or some other kind of undue influence against a party or someone in their family to put pressure on them to settle. Equally, where those letters could be evidence of perjury or blackmail, without prejudice simply cannot apply. And without prejudice also cannot be used simply to explain a delay, because that doesn't really amount to an attempt to settle. And as a final word, it's important to note that there are differences between this type of privilege and other types of privilege, which I will cover in another video. For example, litigation privilege or legal advice privilege. As this video is dealing specifically with without prejudice privilege, the differences are important. For example, legal advice privilege would be confidential to the party that owns that privilege, whereas without prejudice privilege belongs to both parties and is not confidential between the two, because both parties will have seen the correspondence so marked. And as I said, both parties own this without prejudice privilege, so it would require both parties to waive this privilege. In other words, lift the veil and allow others to see it. And if parties do waive this privilege to a particular document, then generally that is taken to be all matters referred to or stated within that document. And as you've probably picked up, this without prejudice tag is not absolute. The court can lift this veil if it considers it necessary to do justice between the parties or balance the interest of the parties, and as in the examples I've given, such as threats or outright fraud. So without prejudice can be a very important and useful tag to put on letters in genuine attempts to settle, but don't think that this can cover up any kind of threats or oppression or any other kind of undue influence against the party or members of their family, for example, which we have seen. So as always, this is a very complex area which you really should take advice on before marking something up as without prejudice, because otherwise you may incorrectly rely on that tag and be compromising your position. This is why I always say that you should always get formal legal advice. But in the meantime, I hope that broad explanation was useful, and remember, stay humble and subscribe.